Good afternoon, everyone. Thank you all for joining us today for Foundations of Tribal Consultation and Visions of its Future. This is part 2 in a 3-part Tribal Consultation series. My name is Kara. I use she, her pronouns, and I'm the program coordinator at Partnership for the National Trail System, or PNTS. I will be serving as today's webinar moderator. I'm speaking to you from the lands of the Onondaga and Haudenosaunee people. PNTS recognizes that land acknowledgements are just an important first step in acknowledging we are on stolen Indigenous lands. There will be a link in the chat where you can explore what lands you currently reside on. Please enter into the chat what lands you're joining us from and let us know what organization you are affiliated with here today and introduce yourselves. So PNTS recognizes the need to commit further and engage in meaningful partnerships. PNTS is committed to working with Indigenous people, organizations, and communities, and having Indigenous people lead the way through initiatives such as this Tribal Consultation Series led by Indigenous professionals. Our commitment proceeds into the future through projects such as the Indigenous Mapping and Research Project, which provides resources to help advance National Trail System awareness and education of Indigenous knowledge and stewardship. This webinar today is being recorded and will be available to everyone that registered following the live presentation. The session today will go for about 90 minutes, and we will have time at the end for Q&A with our presenters and some discussion. For those of you who may not be familiar with the Partnership for the National Trail System, PNTS is a small nonprofit that is a collective voice, a resource provider, and a hub for exchange, learning, and action for the National Trail System. As the only 501c3 nonprofit organization focused on the 30 national scenic and historic trails, PNTS brings together professionals, leaders, and trail and hiking enthusiasts to promote a thriving, accessible, and inclusive national trail system. On behalf of PNTS, I would like to thank the National Park Service, Bureau of Land Management, and U.S. Forest Service for their leadership in developing this Tribal Consultation Series. Now it's my pleasure to introduce today's presenters. We have Susan Johnson with the U.S. Forest Service and Eric Chiasson with the National Park Service. And now I'll hand it off to Susan to get us started.
Hello, everybody. My name is Susan Johnson. I'm a tribal member of the 3 affiliated tribes, the Mandan, Hidatsa, and the Arikara Nation, located in North Dakota. Our homelands are all the way from North Dakota, Montana, down through South Dakota and Nebraska, up through the Front Range. And it's really my pleasure to be here today. So thank you for the invitation. Thank you to all of the coordinators of this very wonderful opportunity for everybody to come together and listen and learn and have discussion and dialogue. Very appreciative to everybody who helped set this up. I work for the Forest Service. I was formerly the Regional Tribal Relations Program Manager for the Rocky Mountain region of the Forest Service. Recently accepted a new position with the Washington office, working in forest rangeland management and vegetation ecology as the Tribal Projects Coordinator. I'm going to be visiting with you today about the fundamentals of tribal consultation and some historic perspectives. And to do that, we're going to showcase my slides, and I'm going to go off camera. We're going to start with the overview. These are the discussion items that I'm going to be talking about today. A lot of this is really based on 20 years and more of working with the Forest Service in developing tribal consultation policies for the Forest Service and working across the board with our sister organizations to know and understand what the critical elements for developing a consultation policy look like for various objectives and reside within various regulatory systems. So today I'm going to be talking about, I'm going to provide an overview. We're going to talk about the definition of consultation. We're going to really explore the executive order and the consultation elements. And then at the end of my presentation, I'm going to share some other things for you to consider in the context of consultation. Kara, go to the next slide, please. This is Susan saying this. This is how I have distilled my many years of working with tribal nations in a land managing agency around the cornerstone of communication. And consultation is a legal mandate for federal agencies. And to me, consultation is the cornerstone of any substantive interaction between tribal nations and the federal government. Next slide, please. One of the important things to note here is that consultation has been going on in some form or another since President Nixon. And in his tenure, and people have a whole bunch of opinions about what he provided during his administration, but for tribal nations, he was one of the first really to step up and recognize this sovereignty that was inherent in tribal nations. And he recognized and he supported a government-to-government relationship and built out on that with self-determination and other important pieces of policy to heighten the relationship between the United States and the federal government. And every president since Nixon, and Clinton was the one who really crafted the executive order, everyone has created a definition for consultation under their administration. Clinton devised an executive order, and others have created memorandum that support the executive order and put other interesting nuances into their memorandum. They all continue to advance and take more seriously with each administration the relationship between tribal nations and the federal government, and the obligation that the federal government has to the indigenous peoples and the tribal nations of these lands that are now called the United States. You may have seen the latest memorandum that came out of the Biden administration, stronger than ever. This administration has also issued multiple executive orders and joint secretarial orders to advance meaningful budget dedicating meaningful guidance to strengthen the relationships between tribal nations and indigenous peoples. Okay, we could go to the next slide. This might be going faster than I thought. What I wanted to share here is there are many flavors of how we interact with tribes. Today we're focused on consultation, and consultation is a legal mandate for federal agencies when we are conducting policy changes or revisions, conducting new regulations that might be found in the Federal Register, basically anything that will affect a tribal nation and their standing and their interests. The federal government is compelled to consult with them. So, the formal definition is an action or process of formally consulting or discussed. The thing that the tribes find interesting about this definition and the process of consultation is you can consult and we can receive your information on the federal side. But how does that influence our decision at the end of the day? Is the federal agency compelled to integrate the direction that is provided through consultation into a decision? And therein lies the problem, I think, for tribal nations in that there is no cause of action in a consultation policy necessarily. We do it in good faith, but there's a prerogative that resides with the federal agencies. Most of the time, the consultation happens between staff to staff, 80% of it, in the Forest Service. For us to designate consultation as formal government-to-government consultation, a decision maker or a line officer must be part of those discussions and those consultations. And that is the high bar set for qualifying government-to-government consultation. Each agency does it slightly different, how they will determine the consultative standard for their agency. There's also coordination, which leads to consultation, and a lot of collaboration. So every one of these three, in some percentage, is always involved, I think, in the conversations with tribes. This is not only for the federal agencies, but certainly for nonprofit, for academics, for other nations interested in working with tribal nations. Okay, let's go to the next slide. So let's distill the Executive Order 13175 a little bit. And this, again, came out of the Clinton era. As he was and others were really compelling the federal agencies to move more descriptively about what is that relationship that we are to have with the tribal nations, and how are we to comport ourselves to engage with tribes? What is the framework? What is the guidance? I've highlighted here for your information. It doesn't look very highlighted to me right now. It might to you. Maybe some of the key phrases that we hone in on. The consultation is desired to be regular. The consultation is desired to be meaningful in collaboration with tribal officials. Tribal officials are representatives of a tribal government that have been selected by federally recognized citizens. And we can get into that a little bit more later, but in this context, tribal officials are federally recognized tribes, slightly colonial still, this power dynamic that exists between the federal government and tribes, in that they may or may not hold this distinguishing moniker of being federally recognized. There's a whole situation around that, but in this executive order, those are the individuals we are directed to consult with. Also, it needs to be meaningful. I've always found this, and a lot of people have, what is meaningful? How do you define meaningful? Some of our folks have said meaningful intent. We intend to have meaningful consultation. But for me and others, meaningful is a collaborative description. Is it meaningful to the tribes, what we are presenting? What is the meaningful standard for the tribes? Do they agree that what we are conducting is formal consultation is meaningful to them? These are some of the questions that I ask myself when we are creating an environment of collaboration and consultation. And then again, in this particular phrasing, that it's government to government relationships, recognizing the sovereignty of the tribal nation as being self-directed. All right, let's go to the next one. Here, I think what I'm really trying to point out is that anything under this umbrella of consulting with tribes under the federal mandate, it is about anything that has a tribal implication. Well, tribal implication distilled to my elementary understanding of that is indigenous peoples. Indigenous peoples have then been collected into tribal nations, and tribal nations as indigenous peoples on these landscapes are affected or influenced or care about virtually everything that the federal government does. And so there is, at some point in time, a consultative requirement for most of the things that the federal agencies engage in, that they need to consult or confer with tribal nations. All right, we could go to the next slide, please. As I said, tribal officials is an elected official from an Indian tribal government. It doesn't say federally recognized here, but that's what it means, because in the definitions of Indian tribal government, it does say federally recognized. And there is a list of, I'm not sure what we're up to now, 500, Eric will know, 500 and under 570 maybe, federally recognized tribes that the federal government is compelled to consult with under this provision. All right, let's go forward. In the executive order, there are fundamental principles identified. And this harkens back to some of the legal framework that has been established through case law, laws and statutes, executive orders. And Eric and I were visiting a little bit about this, but the fundamental principle here that I've highlighted is domestic dependent nations under the protection of the federal government and the United States. This is who this particular executive order is speaking to, vis-a-vis all federally recognized tribes, okay? So what do we do about the tribes that exist and have clearly a traditional and historical connection to the landscape as Indigenous peoples who are not yet federally recognized and under the domestic umbrella of protection and that and an established government to government relationship. So this consultative process covers most of the Indigenous peoples who have joined together in, again, a kind of a colonial term, a tribe that is federally recognized in this particular time and place and system. Also down here is this idea that the federal government holds a trust relationship with Indian tribes, whereby the federal government works as a trustee and works on behalf for Indian tribes, always keeping their interests first and foremost as we engage in our actions, our regulatory agendas, our projects, whatever that is. We hold a trust responsibility for tribes, and we have to ensure that our actions do no harm, principally, in that trust relationship that has been established through case law. And Eric and I were visiting earlier the workshop and the webinar that was provided by the Native American Rights Fund. They did speak to this and establish and frame out sort of that federal Indian law piece, which it goes into more explanation about what is that trust relationship. But it is identified in this executive order, which is compelling and important for us to consider. Okay, let's move forward. Here again, we are talking about these fundamental principles. Indian nations are considered domestic dependent nations, really strengthening that government to government relationship, and that it has to do with honoring and looking at Indian self-governance, tribal trust assets and resources, tribal treaty, and other rights. Tribal trust resources are not only found on today's contemporary Indian territories, reservations, they are found in the national forests. They are found in the National Park Service, because tribal trust resources are Indigenous trust resources. So you have to extend this particular executive order to think about in terms of when you see tribal, think of Indigenous. All right, let's go to the next one. Again, here we are, we're setting up and continue to reiterate when in the policy making criteria, this important and unique legal relationship between the federal government and Indian nations. There is no equivalent. There is only this very unique relationship between the first stewards of these lands, who we are calling federally recognized Indian tribes and indigenous communities, to the federal government. There is sort of a similar relationship between maybe states and the federal government, but it is not the same, because the indigenous people who have now collected into these tribal entities have this unique relationship with the federal government based on historical, a long time ago, historical interactions and the presence of indigenous peoples as newcomers were coming to these territories. All right, let's go to the next one. So this is very challenging, and we try to do this all the time. What is the accountable process to ensure meaningful and timely input by tribal officials in the development of regulatory policies that have tribal implications can be captured or have been satisfied? This is one of those challenges that is always shifting and changing depending on the scope, the intensity. What are we talking about? We're talking about the mining law, at least for the Forest Service, in a multiple use environment. Are we talking about timber sales? In the Forest Service, we have identified 120-day, we had to put, a criteria out there, 120 days to consult with Indian tribes on big actions, on any action that we are involved in, to allow them enough time to work through their tribal system. And each tribe is different depending on how they're staffed out. Some have really built out departments and department heads and natural resource directors, and others with traditional territory in the locations where we're trying to implement a project or program may not have similar resources. So we provide 120 days. If the 120 days isn't adequate, we try to accommodate that. Sometimes when things hit the Federal Register, or we're in the throes of forest plan revision, let's say, which has its own timeline, matching them up can be a challenge. And that is the challenge of the local unit, to ensure that we have provided tribal nations appropriate time to engage with us on things that they want to invest their time and energy on. Okay, next one, please. So these are always the disclaimers, and I'll, Eric might go into these a little bit more, but all of that said, here's the disclaimer: doesn't create a right or a benefit or a trust responsibility. And so it's out there for everybody to see. We all understand that. We accept it. We adopt it. But that is the intent, is to create a meaningful and strong government-to-government relationship with the tribes. Next slide, please. Yeah, we come to a screeching halt on that one. And the tribes are like, why should we invest in consultation when you may or may not take our input? How does that advance our sovereignty and our connection to our traditional ecological knowledge and our sacred sites and the place where we practice our religious freedom? So, but the intent is there. And we work through a variety of laws, executive orders, MOUs, memorandum, to cobble together something that is going to meet the needs of the tribal nations in a way that is fulfilling. It doesn't always happen. It doesn't always happen, but that is always the intent for the federal government side. Tribes are suspicious, and they have a right to be. It hasn't always played out in their favor in consultation. Again, consultation is receiving input, discussion, and dialogue, but there is no obligation to accept and integrate that input into a final decision. Let's move forward. Which is why I bring this up. And many of you probably have read this to a certain extent, the UN Declaration on the Rights of Indigenous Peoples. The interesting thing about the UN Declaration is that it was crafted, drafted, thought about by Indigenous people for Indigenous people, which is a juxtaposition to the consultation policy. This is Indigenous people looking out for the rights of other Indigenous peoples, which makes it extremely valuable. It was passed in 2007 by the majority of the UN delegation. The United States did not adopt it at that time, but later adopted it in 2011. It was under the Obama administration that we adopted it, along with 2 other nations who did not accept it in 2007. Okay, we could go forward. Here's the terminology of the General Assembly. It affirms and articulates sort of what we're talking about here and the basis. It identifies a concern that Native peoples or Indigenous peoples across the globe have suffered from historic injustices. We see that it's still present in our systems. There is still systemic racism in our systems. There is, a lot of work afoot to decolonize some of the systems that we are working in as we move forward with tribal nations. So I wanted to share that because it is important that there is this foundational understanding of what the UN Declaration, one of its platforms is. Okay, move forward, please. This is what tribes are upholding as sort of their standard. Now, again, the UN Declaration was written by Indigenous people, for Indigenous people, for the United Nations to adopt as we think about Indigenous peoples on the globe. Article 19 has been upheld by many tribal nations, not only in the United States, but around the globe, as the standard of what consultation should mean and could mean. What tribal nations are looking for in a consultative process is that whatever entity they're engaged in obtains their free, their prior, and their informed consent before adopting or implementing legislation or administrative measures, policy and projects that may affect them. We in the United States are juggling what the consultation policy is provided to us, and it's good, it's a good umbrella, and this one. And I think there's a blending that needs to happen. But when the tribes say this is sort of their preferred approach to consultation, we have to take that seriously. Now, we really haven't established, and maybe Eric knows, any policies within the federal government that administers that. And I'd be interested to know that if that's the case, but I just wanted to share that with you because it's not only the federal government, these are also practical. This is also practical guidance for any entity to follow. Okay, let's go ahead. I wanted to share these other consultative, other laws and executive orders that have a consultative requirement. The Native American Graves Protection and Repatriation Act of 1990, as amended, provides for the return, the repatriation, and the reburial of Native American ancestors who have been dislocated from their resting place. And this includes their funerary objects, cultural patrimony, and sometimes sacred objects. To do this work, to implement NAGPRA, you must consult with tribes. They are the knowledge keepers, the knowledge brokers in this case, and they know what those items are and who those people belong to. Secondly is the National Historic Preservation Act, Section 106. This is probably the most familiar consultative requirement among land managing agencies, and it's generally carried out at a project level basis with our heritage staff. But it is about identifying if there is any adverse action that may happen because of a proposed action on federal lands. Again, it's a land managing agency, you know, almost a daily consultative requirement. Of course, there's NEPA. Oops, I missed sacred sites. For sacred sites, there is a consultative requirement here, in my opinion, and how it intersects with Section 106. There are traditional cultural built environments that the National Historic Preservation Act administers to. Sacred sites are not always a built environment, but they can be affected nonetheless with a proposed action. So there is a need to consult for NHPA Section 106 and for sacred sites on any proposed action that a land managing agency may conduct. And then, of course, there's NEPA, and everybody's very familiar with NEPA. It has to do with, even before scoping, let's get into meaningful coordination and consultation with tribes. They can help drive the project's design, ideally. But the CEQ does compel the agencies to get tribes involved in these proposals. All right, let's go ahead and move forward. What happens if you do not consult from a federal standpoint? We recently had a case, and I believe that you will be hearing more about this in an upcoming webinar. The Trail of Tears is a trail for tribes located in the Southeast Florida panhandles, that area, Louisiana, all of those areas. They were removed from their traditional homelands and moved into what they called Indian Territory, Oklahoma. There's a trail that the Native people and others refer to as the Trail of Tears. It's a devastating event. If you don't know about it, I would ask you to go ahead and read a little bit about that. Part of that trail does go through the national forest systems, and without consulting or tribes, we performed an action that was very harmful to the continuity of the trail, very harmful. And it was a physical project which damaged the continuity of this trail. And it was very harmful psychologically and emotionally to the affiliated tribes to that trail, because there was no consultation. When they found out, they were horrified, as they should be. And the Forest Service had a lot of reparations to make, not only physically, but to the government relationship and to the Native communities. It was a very emotional, and continues to be a very emotionally heavy misstep, I'm going to say. And that is just one of the most recent examples of what happens if you don't consult. If we consulted, we would have known, maybe absolutely, to move the project from or deliver the repair in a different way. What happens if you don't consult if there's a sacred site in the area. Sacred sites are traditional knowledge, and you may or may not know about it because they're not a built environment, and we can lose them. And that is devastating to the continuity and the traditional and religious life of those affiliated tribes. They lose cultural connectivity. There's a degradation of our relationships. We get the reputation of checking the box or not affording opportunity for their input. The list goes on, as you can see here. So there's probably a lot of other things that can happen, but I just wanted to keep it on one slide. All right, let's go. Next slide, please, Kara. Yeah, that's my PowerPoint presentation for you all. And I really thank you for your time and listening to me. If you have any questions, please put them in the chat.
All right, I guess I'll take it over. Thank you, Karen, and thank you, Susan, for setting me up so well. I think I might move through my presentation with a little bit of a purpose so that we can get to some questions and maybe have some conversation at the end. I know we all enjoy that, so I'll get right into it. Quick introduction. A little bit about me. I'm Eric Chiasson. I'm the Regional Tribal Liaison and Native Affairs Officer for Region 1 of the National Park Service, otherwise known as North Atlantic Appalachia. I grew up in central Maine. I'm an enrolled member of the Eskasoni Mi'kmaq. My mother's side of the family are from the Eskasoni Reserve in northern Nova Scotia. I have family in central Maine as well, who are also from Eskasoni. Why don't we move to the next slide? Good, Kara. All right, I like to start with this map. Usually I'm talking to Region 1 folks, and this allows them to sort of situate themselves in our region, see themselves in their parks. And it's a good lead in to the next map, if we could go there, Kara. This is Region 1 from a different vantage. These are the traditional or the areas of tribal interest that our parks are concerned with when they are engaged in different sorts of mandatory consultations. It's an illustration of the 47 nations in Region 1 of the Park Service that our parks programs consult with. 35 of those 47, 35 are federally recognized. The other 12 nations are state recognized, but they may not necessarily be state recognized. And that's sort of an interesting feature of Park Service policy that we'll talk more about, that I think is usually of interest to folks. That yes, our consultation policy, our federal consultation policy is the DOI consultation policy, and this is with federally recognized tribes. But as a matter of Park Service policy, for reasons flowing from cultural resource law and a trust responsibility, and other reasons, the fact that the Park Service stewards the nation's cultural resources and has a public trust responsibility to understand and interpret these resources for the public, and to that end, it's the policy of the Park Service to consult broadly. If we could go to the next slide. All right. To sort of frame and give a little bit of a background to government consultation and a policy of supporting Indian self-governments, we can say that under United States policy of Indian self-determination, federal government recognizes the need to abandon the failed policies of paternalism and assimilation to instead promote tribal sovereignty through partnership with tribal nations. So when we're talking about failed policies of paternalism, assimilation, I think that our NARF folks did a great job talking about these. But just sort of broadly or quickly, we're talking about the policy of Indian removal. We're talking about allotment. We're talking about the policy of terminating federal recognition. Throughout that time period, we're probably also talking about the system of federal Indian boarding schools that we continue to learn more about in the course of the Secretary's work. And we sort of now arrive in this era that Susan had spoken about, and which is one of supporting and promoting self-determination. So DOI policy and regulatory approaches are now aimed at empowering tribes to more directly manage their own resources and lands, engage in economic development opportunities based on their own strategies and priorities, and to self-govern through their own independent judgment and cultural values. So the policies that we see in this period, sort of post-Nixon, beginning in 1968, we'd be talking about the some legislation concerning civil rights. In 74, we have legislation concerning financing of tribal initiatives. In 75, we have ISDEA. Important feature in that statute is 638 contracting. In 77, that's an important year. We have American Indian Policy Review Commission, and there'll be more to say about that later on. In 82, there's some legislation about tax status and placing tribal nations on the same footing as states in that regard. In 88, there's legislation concerning schools and the tribe's ability to administer schools. In 2000, we have Clinton and Executive Order 13175, which is really probably the departure point for not only DOI's consultation policy, but all of the different departmental consultation policies that very, very firmly situates it in government to government frame. It establishes that frame. In the 90s and 96, we had legislation around housing. And we might add to this in 1990, we have some cultural resource law. NAGPRA was passed in 1990, and the NHPA, National Historic Preservation Act, is amended in 92 to include tribes and tribal concern. We go to the next slide here. All right. So here's a slide that there's too much text on the slide, but what I've attempted to do here is distill the important features of the DOI consultation policy. So sort of the guiding principles that inform the policy as a whole are the idea that consultation is between appropriate tribal and departmental officials. So by that we mean officials that are knowledgeable, that are informed, and have decision-making authority. Another principle, engagement early in the planning process with a meaningful opportunity to participate. So this is to say that engagement is early enough so that tribes aren't merely being presented with a plan in which they had no role or input in scoping or no opportunity to express concerns that are much easier to address early in the process than they are later. And just that meaningful opportunity to participate. It has to be meaningful. There has to be that space for exchange of information, exchange of understanding, and the ability to see that reflected in what comes out of that process. That process is meant to be open and transparent in that exchanging of views and information, right? Because it needs to promote that foundation of trust, respect, and shared responsibility. That idea that yes, this is meant to be an inclusive process that is meaningful, participatory. Sometimes the reality is that there can be timelines involved in some of the work, and so part of shared responsibility is understanding that yes, that the agency has to get as early as it can to the tribal nations what it is that we're talking about, what it is that we're talking about developing, and the tribes likewise are going to need to make that good faith effort as well to contribute the views in a timely manner that would allow the process to move forward when that is the case. It's not always the case, but sometimes that can be. And finally, that's just conducted in a good faith manner under best governance practices. So next year, I've got I think probably the most important definition out of the DOI's consultation policy. You would also find its genesis would be Executive Order 13175, and it's this departmental action with tribal implications. How do we know that we're in this realm of DOI consultation policy? Are we talking here about a departmental action that has tribal implications? If we look at the language here in the first part of that definition, I'll read it, but then I'll draw our attention to a couple places. Any departmental regulation, rulemaking, policy, guidance, legislative proposal, grant funding formula changes, or operational activity that may have a substantial direct effect on an Indian tribe on matters including but not limited to. So I would draw our attention to a couple of places that can be contentious, and also, interestingly, you will see differences in interpretation between solicitors sometimes, but certainly between departments who have exercised their discretion to interpret what Executive Order 13175 means for them. A lot of times their mission is going to inform that interpretation. But what I would pay attention to here is this idea of substantial direct effect, right? If we want to take a narrow reading of this definition, that's where we would do it, right? We would insist maybe on like place the burden on showing that we're really talking about a substantial effect, right? But if we want to take a more liberal reading of this, then we would focus more on what occurs a few words before that an activity that may have a substantial direct effect, where we're not suggesting that or expecting that we're talking about a really high standard like legal causation for substantial direct effect. That there will be times when it's absolutely more appropriate, and we ought to take that more liberal reading, especially as we go into the categories here that are listed out. Tribal cultural practices, land resources, or access to traditional areas of cultural or religious importance on federally managed lands. And I think it's interesting, and if folks wanted to go take a look, there is a publicly available draft of a DOI consultation policy that's been consulted out, and we'll probably go through another round of revision before it's finalized. But it certainly takes into account this idea of centrality to core interests, right? And like Susan was sort of saying, that this idea of the need for consent in the course of consultation. So under the draft policy, there is this consensus seeking requirement. And how it works is that when you are sort of consulting in an area that is a core concern or is of central importance to the tribe, then there is an expectation that you reach something more approaching consent. And if you're not able to do so, there's a process that will be laid out for sort of resolving where there may be misunderstanding or disagreement or dispute. Sort of at the bottom of the slide, we describe the broadly the stages of consultation. Right, we have an initial planning stage. We were saying before that this is where the agency, the parks, and so forth really ought to be approaching the interested tribes as early as possible to understand the interests, to understand the concerns. With that sort of input, they're able to then scope and return to the tribes again with another opportunity to see what has been scoped, how any concerns have been meaningfully addressed, and whether, if mitigation or other measures were required, whether they really were meaningful and genuinely do address the concern. And if they are, then we're able to move into that third stage, that implementation of the final federal action, where the action is taken, it's implemented, and the agency or park, whoever the federal land managing actor may be, also has the ability there, as it's consistent with applicable law, to invite feedback in order to consider how consultation went, to assess need for further training on the federal side. Did this go well? Do we need to address some concern with how this went with cultural competency, these sorts of things, or is there a need for technical assistance? Could the tribe benefit from technical assistance flowing from this action, or we've learned about a need in the course of the consultation around? Could we go to the next slide, Karen? Right. And so this is a segue into some discussion about the trust responsibility, which I'd sort of describe in this way, that consultation is a necessary procedural step that allows the federal government to understand tribal interests following under the broad headings of sovereignty, services, tribal resources, and any associated fiduciary obligations. Now, how we might say that differently is that, in order to know and to understand, or we can't understand what the interests and concerns and potential areas of fiduciary obligation are unless we're consulting, we're talking to tribal nations, and they're telling us what it is that they care about and what it is that what their concerns are as they relate to the federal action, whatever it might be. But more on that. This is where I like to talk more about that concept of fiduciary obligations, because it's one that can be a little confusing. And the reason for that is because sort of it speaks to the special relationship that flows from a framework that sets up the federal government as a guardian of tribal nations, this domestic dependent nation framework. It's a legacy of the John Marshall court cases. So at its broadest, that special relationship that's described by fiduciary obligations, it consists of legal duties, moral obligations, understandings, and expectancies that have arisen from the entire course of dealing between the federal government and tribes. Okay, at the same time, in the narrowest and most concrete sense, it approximates that of a trustee and beneficiary, the trustee, the United States, subject in some degree to legally enforceable responsibilities. What's unfortunate is that a lot of the times the same terms describing fiduciary obligations are used by courts and legal commentators, whether they're referring to the broadest understanding of that concept or the narrowest understanding. But returning here to the discussion, when we're talking about the trust responsibility, such responsibilities may not be limited to management of traditionally understood tribal lands and trust assets, and they potentially reside within cultural resource law. In particular, in the nexus between the nation's cultural resources and its policy of supporting Indian self-determination, cultural revitalization through partnership with the federal government. Now, in a region like mine, Region 1, where we don't have large reservation land bases, and it's not characterized by a great deal of trust assets. But that's not to say that the fiduciary obligations aren't there, because we'll find them most clearly in the cultural resources themselves that the National Park Service administers. So that's sort of the point that I'm making at the bottom. For the NPS, the Cultural Resource Administering Agency of the United States, there are implications for a present and future interpretation of fiduciary obligations, owing to the fact that resources of substantial tribal interest are stewarded by the agency. So, for example, what we're talking about here are archaeological resources, ethnographic, cultural resources, natural resources, sacred spaces. These resources often implicate the core of tribal nation identities, cultural life, ways of knowing, cultural distinctiveness, and may have implications for sovereignty. So that is sort of at the core of the trust responsibility and would activate it in its strongest sense. I think it's also important to talk about there. I like to refer to the federal recognition context, right? And the fact that the process of federal recognition has been described. I'm thinking now about a case involving the Mashpee and the New Seabury. This was a challenge to their recognition. But in that case, what I'd like to pull out of that is the way that the court characterized the process of federal recognition. They characterized it as an inquiry into cultural distinctiveness. And that's where the importance of these resources can really be highlighted, because they are so central to the identity of these nations. So the responsibility is commensurate with that importance. We can go to the next slide. All right, a little more discussion of the trust responsibility because it's really important. The obligation for federal agencies to engage with Indian tribes on a government-to-government basis is based on the U.S. Constitution, federal treaties, statutes, executive orders, and policies. The important point here too is that the whole of the federal government assumes this solemn charge to work with tribes on a government-to-government level to address Indian self-government, tribal trust resources, Indian treaty rights, and other rights. I like to emphasize other rights for some of the same reason that I mentioned before about just the nature of Interior Region 1, in that it's not characterized by a lot of treaties, in addition to not having large reservation spaces or trust assets. But through that category, other rights, which I think the genesis there is also found in Executive Order 75, and we could bring in the trust responsibility broadly in there, I believe too. Is that category, other rights? I think that's relevant to a discussion about the future of consultation with tribal nations and the idea of an evolving relationship, which is where I like to bring in the chapter on the trust responsibility from that American Indian Policy Review Commission, 1977. There's this great analogy that they draw between, I'll just read it, like the U.S. Bill of Rights, the trust responsibility in its social and government aspects is a constantly evolving legal concept that's left unenumerated for flexibility and meaning that accounts for its continued vitality and relevance. It's important to understand, right, that this is not a fixed concept, right, and it's very relevant to something like the United Nations Declaration of the Rights of Indigenous Peoples, which reflects an evolving international understanding of what those relationships between colonized settler colonial governments and the indigenous peoples that they've colonized, what those ought to look like. We can move to the next slide here. Okay, so back into some more discussion about government-to-government consultation. Say here, just broadly, right, the intent of the DOI and NPS consultation policies is to ensure that consultation meets legal and moral obligations under the law, go beyond the floor of statutory compliance. For example, in the Section 106 of the National Historic Preservation Act context, the statute requires that the NPS ensure impacts to environmental resources and important historical and cultural sites are considered in the development process. Okay, and then it also further requires that those affected by development have an opportunity to participate in decision making. Go to the next slide. Enter here some criticism of Section 106. And the criticism consists in this, that their commentators will suggest that within the language and the structure of that statute, there's a presumption that having considered tribal input and mitigated, et cetera, that development or whatever that departmental action may be, may proceed, so long as all of the procedural requirements are met. You have to remember here that consultation is a procedural requirement under the NHPA, that competing interests are balanced against tribal interests. So what are we talking about here? We're talking about the reality that meeting procedural requirements, reaching out to tribes for input and receiving that input, taking that input and balancing it against the public interest, right? That's the exercise, that's the procedural requirement that is expected to be reflected in the final decision. So sort of the reality there is that, that may not be all that difficult to achieve, to demonstrate that you've taken tribal input, that you've considered it, and that you've weighed it against perhaps competing public interests, right? So the problem enters in that for an administrative law judge who might take a look at a decision, what they're looking for is two things. And the reason, the obstacle, right, is that the administrative law judge is going to be reluctant to substitute the judgment of the court for the judgment of the agency, which has been delegated that authority from Congress. It's not going to substitute, it's going to be reluctant to substitute its own judgment for the judgment of the subject matter expert who has been delegated that discretion under congressional authority of some form here, the NHPA. So this is the Chevron doctrine and the Administrative Procedures Act. So as long as, the record isn't clearly arbitrary and capricious in its reasoning, or there's no defect in the procedural steps in consultation. They actually did solicit tribal views. They actually did account for those views in the writing. Then there are instances where development or the action can move forward in ways that are problematic, but there's the ability or the recourse is limited, I guess we might say. And that's sort of brings me to the other point on the slide here, and some comments that we first saw with President Nixon, right, who spoke directly to the occasional egregiousness of certain conflicts of interest that can arise in the course of dealing. So here, a good example of that may be decisions that have to be made about water resources, where tribes have rights to water resources and the public has a strong interest in those same resources. What Nixon had criticized was the idea that it can be the case, it has been the case historically, that the same legal team in the Department of Interior is sort of responsible for both sides of that ledger, and have made decisions historically. There's been a lot of litigation around this, deciding how these resources are going to be divvied up, right? And so what he sort of what Nixon was saying there, his criticism was that no self-respecting law firm would ever internalize such a conflict of interest. Yet that is what, as the Rehnquist court said, that's what Congress and its plenary authority over Indian affairs has directed the Department of Interior to do, to carry water on both shoulders, so to speak. And the court believes that there's no reason why it can't do that. And this is not to say that the department doesn't evolve in its approach to those responsibilities. It's has historically encountered instances where it's been forced to evolve. Here I'm thinking about the Cobell settlement, 2009, I guess, $3.4 billion for mismanagement of trust assets, right? So there's a 400-page Cobell Commission report out there that sort of describes all of the problems that culminated in that, and laid out a series of recommendations for how the department could handle that, some of which they've adopted and some of which they haven't. So we consult in part because the DOI is instructed by Congress to balance what can be competing or conflicting responsibilities under both the public trust doctrine as well as an Indian trust doctrine. Consultation is therefore critical in addressing the question whether the federal government may develop federal resources in ways that harm tribal interests. All right, next slide, please. And here, I'm not going to read all this, but I wanted to end here. This is interesting. This is that feature of Park Service policy that I'd referred to. It's the fact that under Park Service management policy, parks programs are expected to consult broadly, and those consultations are not limited to federally recognized tribes. The expectation is that your cultural resource managing agency, and there's a public trust that you're invested with to understand and to interpret the resources that you steward. To do that necessitates broad and inclusive consultation. So if folks would like to talk more about it's an interesting subject. It certainly can give rise to some interesting situations, some difficult, challenging situations sometimes, right, where you have federally recognized tribes who may not necessarily want the federal government to be consulting with state recognized tribes or non-recognized tribes. And these are difficult questions. A lot of them are driven by circumstances and facts on the ground. So why don't I end there, Karen? Hopefully I didn't go too long.
No, we've got about 15 minutes for questions, which is great. Megan asks, other than the Pueblo of Sandia case, do you have any examples of cases establishing minimum criteria for consultations?
That's the Forest Service Sandia Pueblo legislation. They received lands that were from the Cibola National Forest backed into their as a trust asset, and there was a deliberate process outlined for consultation and how they would engage in real decision making, project management on that unit. And I can tell you that no, there is no other case kind of with that prescriptive legal interaction that I have seen in the Forest Service. I haven't seen everything in the Forest Service, and that's a recent case. But later down, I think it's Amanda Grace who does even bring up the land back movement initiatives. There's some legislation out there. I mean, this is getting more interesting as time goes on around federal lands transitioning back into tribal ownership. So the potential is there for something similar to the Sandia Pueblo case, as far as prescriptive consultation processes.
Thanks, Susan. Our next question is from Callum. Do any entities currently engage in free, prior, and informed consent in a genuine way, or are many not taking consultation discussions into implementation?
Hey, that's a great question, Callum. Tribes are partners to the federal agencies. They own part of the agenda. They own a significant part of the agenda. And I would say that tribes should step into that space a little bit more and bring sort of that framework, those requirements, those desires into the consultative space and start defining what consultation means to them. I haven't seen it yet. Like, again, I don't see everything, but I think it would be very innovative, very progressive to start moving into that space and having the feds respond to what the tribes want, instead of us kind of offering what we think it could be for the partnership. I'd love to see something like that.
And I would just add to that, this is where I was trying to go a little bit with a mention of it's not the current DOI consultation policy, right? But if folks take a look at the draft, that it could very well become DOI consultation policy that really, to a reasonable extent, I think codifies that idea, right, of a consensus seeking requirement. I think that, if it does come to pass, that becomes the policy of the department, and tribal nations assert their rights under that, their ability to challenge actions under that policy, then I think that you would see response from the agencies, right, and from the different federal land managers out there that reflects that reality, right, that they have to be very cognizant of this expectation that is there in the policy, but also that we can expect that the nations would have as well moving forward. And it's very informed by, because that's another interesting thing that you'll see in especially different policy initiatives coming out of the last White House Tribal Nations Summit. See references to UNDRIP throughout, right? And so nations understand this concept very clearly, and that is the direction. And as Susan said, that is the standard, right? That's the future. That's where we're headed. And you don't have to look very far to see it starting to be implemented in practice. Here I'm sort of referring to the fact that Canada, right, has taken a step beyond what the United States has done in terms of taking action on UNDRIP and beginning legally affirming it and beginning to codify it into federal policy. So you'd expect to see those sort of principles reflected in different ways throughout.
Now, Eric, if I could also expand on that slightly. One is, do you have a link to that draft policy that we could take a look at? And perhaps if you could put it in the chat, I think that would be a good link for us to be witness to. And then secondly, if this is the future for DOI, which I would love to see it be the future for DOI, I think that has a snowball effect on the other land managing agencies to update and be more progressive with what they have existing as a tribal consultation policy. I think it'd be great.
Do a little searching around Google, see if I can pull it real quick and throw it into the chat.
Thank you.
Thanks, Susan and Eric. Our next question is from Anne. Do you have sample case studies you can share that demonstrate when these laws and processes were followed with the best intent and outcomes? And I will just quickly say to Anne too, the third part of this consultation series, we will share a couple different case studies, some that we've had to learn from and some that went really well. So I'll just throw that out there as well. I don't know if Susan or Eric, you have anything to add to that?
I have a NAGPRA case, but NAGPRA is its own process, its own specialized process. And I think what we're talking about here is a broader approach and a broader approach to consultation. So I'll look forward to this next upcoming series myself.
Thanks, Susan. We have another question here. How do you see the consultative process evolving with a municipal government?
I'm going to apply, just for the sake of creating an infrastructure, I'm going to apply something that's a standard, if you will, in the NAGPRA statute, and that is tracking federal dollars. If there is a federal dollar appropriated or used or granted or whatever, it doesn't lose its federal color. And because the feds have interest in maintaining kind of that trustee tribal government to government relationship, I think that also tracks with that federal dollar. The federal dollar is imbued with a consultative opportunity and obligation. Not always, but sometimes, right? And it depends on what it is, if it's an NHPA, a sacred site. So it depends. But I do think that receiving a federal dollar, say in highways or in waste management or in air quality, there is, I think, a consultative requirement when you receive those, with their grant dollars or their block grant dollars, whatever they are. So I can see a connection there, a legal tie there for municipalities to conduct consultation with affiliated tribes in the landscape that they have influence over. I would also say that water is a tricky thing for municipalities, and that downstream users could also be affected, of course, by those actions, and perhaps there's a tribal community downstream. So I see connectivity.
I would draw a similar analogy, I think. With the question sort of makes me think about requirements. I'm sort of thinking about instances that I've seen with partners who are doing archaeological work on private land. It's not federal land. They are partnered with the federal government. I don't know that they necessarily even needed to be partnered with the federal government, because in order to do the work on the trail, they were pulling permits from the state, who is, like Susan is saying, receiving federal dollars. So while it may not necessarily pull them under like a section 106, for instance, sort of framework for consultation, I think that they still have the responsibility to consult with the traditionally associated tribal groups. That's my understanding. And I would see that continue to be like that sort of line of reasoning, that there are, you know, the other example that comes to mind are national heritage areas. I think that we could be approaching a space where there's an expectation that, especially in like the formation process, right? Like there'll be a bill to introduced by a state senator to create a national heritage area, but the NPS has a role in reviewing and approving things like their general management plan. I think that what we may very well see is that there's an expectation in the course of pulling together that management plan, that you've conducted consultation, and that so when the NPS gives the green light for its purposes to the creating that heritage area, that in that analysis, some of the efforts, some of the actions taken in good faith to respect DOI consultation principles, sort of describe some of the things that they've done. Well, they did particular kinds of outreach, or they had particular sessions, or might have or holding space in their plan for maybe a seat on the board. Like there are different ways that they would demonstrate that, and that would be reflected in some analysis in relevant section in the course of getting that green light to move forward. Which is just to say that, you know, that perhaps the NPS is not going to set itself up or view itself as a mere pass through for these sort of things, right? Like there are policies that inform what the agency does, and they ought to be reflected in some of the actions, even if they're, you know, we're talking about, you know, spaces that like a heritage area that won't be federally controlled. They won't be federal spaces, but they did have to pass through the NPS in the course of being created and being recommended for approval, but also just the fact that they receive I guess on average $500,000 from the federal government. So I think similarly, we might expect that consultation or something approaching it is a part of that.
One of the agencies, Eric, and feel free to think of another one, but I think EPA really would be integral into any municipality. They receive block grants through the state generally, and direct grant blocks, grant blocks for all kinds of stuff. So EPA is a strong player, I think, in the municipalities, as is Federal Highways Administration. And those are the air quality, you know, those kinds of things.
Great. Yeah, thank you so much, Susan and Eric. We've got just a couple minutes left. I know, Susan, you touched on this a little bit, but Amanda Grace's question, I wondered if you had anything to add to it. She asks, can you speak a little to mixed ownership lands, land back reconciliation, and how these change how agencies engage with policy.
That is such a good question, right?
It's a huge question.
Because it's exactly what we're trying to,
Yeah.
in my corner, trying to figure that one out, right? Especially where it intersects with something like sacred sites, right? So what is the solution where you have maybe a series of sacred sites that are connected as far as the tribal nation is concerned, with whether it's it could be an origin story that links these sites, something along those lines. What are you to do to protect them when they occur in different land spaces, like different kinds of jurisdictions? We've got municipal land, private land, and federal land. Well, it's on federal land, that's probably the most straightforward. State land is probably more straightforward as well if we're able to support a tribal nation, or they can engage independently. A state SHPO about what might be done there. You start to bring in that private land that raises the more challenging questions. Right? Like what do we do there? And maybe part of that answer resides in, well, how can we bring kinds of protection through cultural resource law? If we can get that site listed on the National Register, right? And this would apply to state lands too. Designations that might give us some kind of protection, but ultimately, what do we want to do there? We probably want to change the status of that land. How do we do that? Maybe it's through something like the Land and Water Conservation Fund, right? And maybe there are organizations on the ground there who apply for some of those dollars that come to the states through the formulas, and maybe they're able to work with tribal nations to understand the concerns, where the sites are, what they would like to see those dollars used for, in terms of where's that intersection between conservation values, ecotourism, and protection of sacred spaces. I think that there's a lot of overlap there and potential moving forward, in particular, because it's my understanding that there's a tribal consultation requirement on all land and water conservation grants now. So I think that might create a real opportunity there to start to figure out, how do you answer that complicated question about mixed land.
Amanda Grace, you asked like a whole semester worth of conversation there. And I think it's evolving. I think that even there's new bills being introduced even today that kind of take a swipe at resolving or creating space for these considerations. And the one that I referenced in the chat is on board right now in the House of Representatives, just introduced. And what did they talk about? Well, there's a priority out there for land back. It's treaty lands. It's former treaty lands. Sacred sites, traditional cultural properties. So people are thinking about it, but what's the legislative mechanism to make that happen? That's the thing that we're trying to sort through. There's a lot of policies and a lot of other programs to facsimilate, but I think what the tribes are really wanting is a legislative opportunity to bring their lands back into tribal ownership and participation.
Great, thank you. That is all the time we have for today. So I just want to say thank you to everyone for attending today's session, and a very special thank you to Susan Johnson with the Forest Service and Eric Chiasson with the National Park Service. Before we end for today, I ask that you kindly scan the QR code on the screen and take a very quick feedback survey about the webinar today. And as you do that, I will quickly mention some upcoming PNTS events. The third session in this tribal consultation series will be on September 29th. And during this training, we'll hear from folks from the Forest Service, Katua Nighthawk Consulting, and the American Indian Alaskan Native Tourists Association. And they'll talk more about the differences between tribal consultation, coordination, and engagement, and the responsibilities of different entities in each of these practices. And you'll hear about successes, failures, case studies when engaging with Indigenous communities, and really understand where your role in engagement is as an NGO. I will also quickly mention that registration is now open for PNTS's National Trails Workshop. That's November 2nd through 4th in Albuquerque, New Mexico. And I will share some more information about that in the post webinar email that I will send out with the recording. And if you have any additional questions or would like to get in touch with Susan or Eric, please feel free to reach out. And please follow PNTS on social media to keep up with our upcoming events. And just thank you again to everyone who attended, and Susan, Eric. Have a wonderful rest of your day, everyone. Thank you so much.